Tonight, it is D for docket. When the court says, explain yourself, analyze this mess because somebody has to say it. And again, shout out to the mob. All my other bears I call the grizzlies and the honey bears. Well, tonight we are not dealing with rumors, screenshots, or internet commentary. Tonight we are dealing with the docket. And when the docket speaks in federal court, everybody should pay attention. Well, this evening, when I looked, a new order appeared in the case file, and it changes the temperature of the room. The court has now granted a motion requiring the defendant to show cause. That means the defendant must explain to the court why she should not be held in contempt and sanctioned for failing to obey prior orders from Judge Levy. Let that sink in for a moment. A federal judge issued an order requiring disclosure of the defendant's legal name and address. That order was ignored. A second deadline passed. Still no compliance. So now the court has stepped in and said something very simple. Explain why you disobeyed the court. Because in federal litigation, there is a basic rule that applies to everyone in the courtroom. Plaintiffs, defendants, lawyers, and even pro se litigants alike. You can challenge an order. You can appeal an order, but you don't ignore a federal judge's order. And the court made another point that cuts right to the heart of this case. A litigant cannot use anonymity as both a shield and a sword, meaning you cannot hide behind an alias while simultaneously stepping into the courtroom to file motions, attack the claims, and shape the outcome of the litigation. That tension has now reached the point where the court wants answers. The defendant now has until March 24th to explain why sanctions should not be imposed. Now, let me say something clearly for everyone watching tonight. This is not a victory speech. This is a procedural development in a case that is still moving forward through the legal process. The underlying claims have not been decided. But what this order does show is that the court is paying attention, close attention, to what is happening inside this litigation. And when orders are issued, the expectation is compliance. So tonight on Analyze This Mess, we're going to walk through exactly what this order says, why a show cause ruling matters, and what the next steps in the case could look like. Because when the court starts asking questions like this, the docket just became the most important docket in the room. So, first of all, I'm going to start with a quick, it's only 3.5 pages of what got us here was the filing that I made on February the 2nd. So here it is, 30 days later, 31 days, because it's March the 3rd. So I'm going to read it. We'll go through it quickly. I filed the plaintiff's motion to compel and enforce compliance with court orders and application for order to show cause and hearing ECF numbers 74-124. Plaintiff Sabrina Evans, proceeding pro se, respectfully moves the court for enforcement of its orders requiring defendant Danielle Robertson to disclose her legal name and postal address, and for issuance of an order to show cause with a hearing why defendant should not be held in civil contempt for continued noncompliance. In support, plaintiff states as follows. Background. On September 25th, 2025, Magistrate Judge Stafford entered an order authorizing alternative service and directing defendant Danielle Robertson to file a written notice identifying her legal name and postal address, ECF number 74. Rather than comply, defendant filed motions seeking to avoid or delay disclosure, including a filing later stricken by the court. On December 29, 2025, District Judge Levy struck defendant's filing ECF number 121 for containing fictitious legal citations and noted that defendant had previously been warned regarding such conduct, ECF number 124. In that same order, Judge Levy issued a clear and unconditional directive requiring defendant to file a written notice identifying her legal name and postal address no later than January 5th, 2026, ECF number 124. That deadline has passed. Defendant has not complied and continues to seek relief from the court without obeying its disclosure orders. Here was my argument. A. Defendant is in violation of clear court orders. The orders at ECF numbers 74 and 124 are unambiguous. Defendant was ordered to disclose her legal name and postal address by a date certain and failed to do so. A litigant may not continue to seek relief from the court while disregarding direct court orders. The court has authority to enforce compliance and issue an order to show cause. Federal courts possess explicit authority under the Federal Rules of Civil Procedure and inherent power to enforce their orders and manage their dockets. First, Federal Rule Civil Procedure 37B2A provides that if a party fails to obey an order to provide or permit discovery, the court may issue further just orders. As provided in the rule, these orders may include treating as contempt of court the failure to obey any order except an order to submit to a physical or mental examination. The defendant has repeatedly failed to obey this court's orders, specifically the orders requiring the disclosure of her legal name and postal address, ECF number 74-124. Because defendant has refused to comply with court-ordered disclosure, essential to case management and enforcement of judgment, treating such defiance as contempt is a just order authorized under Rule 37B2A principles and the court's inherent authority. Second, beyond the rules, the court possesses the inherent power to manage its proceedings to ensure the orderly and expeditious disposition of cases. This inherent power includes the authority to issue an order to show cause when a party willfully disregards a direct command from the bench. Civil contempt proceedings are appropriate here to compel the defendant's obedience to the court's previous mandates. C. Defendant's continued defiance prejudices the litigation and renders any eventual judgment unenforceable. The court has repeatedly warned that defendant may not use anonymity simultaneously as a shield to protect her privacy and as a sword to undermine the litigation. ECF number 74, page ID 778. In doing so, the court recognized that without disclosure of defendant's true identity and address, any judgment plaintiff might obtain would be effectively unenforceable. By blowing past the January 5th, 2026 deadline, ECF number 124, defendant has now realized the very risk the court identified. Her continued refusal to identify herself constitutes a strategic effort to ensure that these proceedings remain a hollow exercise. Specifically, defendant's noncompliance impedes effective case management. The court cannot oversee discovery or set meaningful schedules when a primary party remains a phantom. Next, renders judgment unenforceable. As previously noted by the court, defendant's use of aliases and shifting addresses creates a jurisdictional and collection vacuum and subverts judicial authority. Defendant is currently litigating in open defiance of two separate court orders, ECF number 74-124, signaling that she believes the court's deadlines are optional. Absent immediate enforcement and further relief, defendant will have successfully used her anonymity as a sword to paralyze the judicial process without consequence. Relief requested. Plaintiff respectfully requests that the court, 1, enforce its orders at ECF number 74-124 by compelling defendant to file a written notice identifying her legal name and postal address within a time set by the court. 2, issue an order to show cause requiring defendant to appear and explain why she should not be held in civil contempt for failure to comply with the court's orders. And finally, impose appropriate coercive measures if non-compliance continues, including restrictions on further filings until compliance is achieved or such other relief as the court deems just and proper. And I submitted that on February the 2nd, 2026. So next we go to the court's order, the magistrate judge Stafford. Let me just pause for a minute or a second. I'm going to say something in between this. It's going to be simple. It's going to be exact. And I say this with all due respect. I take great offense to any individual who categorizes or characterizes my legal submissions to the court as boring. So this was filed today, the 3rd of March. You can see it. It's ECF number 144. Fair use commentary. It is an order granting plaintiff's motion for order to show cause, ECF number 134. That is the one I just read from. Let's go through it. It is 11 pages. We'll get through it because the last 2 pages are really just instructions. This is the magistrate judge's opinion. Let me just show you right here at the bottom and why she made her decision. We can just go right to the conclusion. The court thus grants Evans' motion for an order to show cause, ECF number 134. By March 24th, 2026, Robertson must show cause why she should not be held in contempt and sanctioned for her defiance of Judge Levy's orders to disclose her legal name and postal address, Elizabeth A. Stafford, United States Magistrate Judge. So anyone is free, to do whatever you want to do. But this is important enough to me that I'm going to read it for my listeners and for the mob. Introduction. Plaintiff Sabrina Evans, proceeding pro se, sues defendant Daniel Robertson and Jane Doe's 1 through 10 for copyright infringement, defamation, fraud, and harassment, ECF number 1. The Honorable Judith E. Levy referred the case to the undersigned for all pretrial matters under 28 U.S.C. 636b1. ECF number 7. Evans moves for an order requiring Robertson to show cause why she should not be held in contempt and sanctioned for disobeying 2 of Judge Levy's orders, ECF number 134. The court grants Evans' motion. Before we get into the background, the footnote above was Robertson made a special appearance as a Jane Doe, stating that Daniel Robertson is an online alias and not her legal name. ECF number 28, page ID 183. For the sake of clarity, the court will nevertheless refer to this individual as Robertson. Background. The substance of Evans' claims has been described in 2 previous reports and recommendations and is not repeated here. ECF number 75, ECF number 138. In relevant part, Robertson is an anonymous online poster who allegedly cyberbullied and made defamatory remarks about Evans on her social media platforms. In September 2025, The court considered several motions involving Robertson's positions that she should be allowed to proceed anonymously and that the action should be dismissed because Evans failed to serve her properly or use her legal name. ECF number 74, page ID 774 through 778, 780 through 81, ECF number 75, page ID 813 through 823. Finding that Robertson may not use her anonymity simultaneously as a shield to protect her privacy and as a sword to undermine the litigation. The court ordered alternate service on Robertson's email address and that Robertson disclose her legal name and postal address. ECF number 74, page ID 778, 781. Robertson objected to the order, and Judge Levy stayed the requirement that she disclose her identity pending resolution of those objections. ECF numbers 82, ECF number 95. Judge Levy overruled Robertson's objections and ordered her to disclose her legal name and postal address by December 15, 2025. ECF number 118, page ID 2393 or 2393. Robertson did not comply and instead moved for reconsideration on December 18, 2025. ECF number 121. Judge Levy struck Robertson's motion for reconsideration because it contained a fictitious citation and ordered Robertson to disclose her legal name and postal address by January 5th, 2026. ECF number 124, page ID 2636. Again, Robertson did not comply. Analysis. A court has the inherent authority to sanction bad faith conduct derived from its equitable power to control the litigants before it and to guarantee the integrity of the court and its proceedings. Whether or not I'm going to read all the references, I'm highlighting them there. Okay. A primary aspect of a court's inherent authority is the ability to fashion an appropriate sanction for conduct which abuses the judicial process. Again, that came from Chambers versus NASCO. Sanctions are appropriate when a party litigates in bad faith, vexatiously, wantonly, or for oppressive reasons. The court's inherent authority also includes the power to punish for disobeying a court's order. Let's take that down. Sanctions permitted under the court's inherent authority include contempt citations, fines, awards of attorney's fees, and such other orders and sanctions as courts find necessary, including even dismissals and default judgments. Egregious misconduct may warrant the extreme sanction of total dismissal or default judgment, but for lesser wrongdoing, a court may assess attorney's fees and costs. A court order must be obeyed by the parties until it is reversed by orderly and proper proceedings. United States versus Hickerson. That's from the Sixth Circuit. And by the way, um, we are in the Sixth Circuit. Even if an order is erroneous, the remedy is to appeal. Without a stay, parties must promptly comply with an order pending appeal. Judge Levy twice ordered Robertson to disclose her identity, and Robertson defied both orders. ECF number 118, number 121. Although Robertson moved for reconsideration of the first order, Judge Levy struck that motion because it contained a fictitious citation. ECF number 121, 124. Robertson thus did not properly appeal Judge Levy's order and instead chose not to comply. Litigants like Robertson, who make private determinations of the law and refuse to obey an order, generally risk criminal contempt, even if the order is ultimately ruled incorrect. That's Manis, 419 U.S. at 458. An exception to this rule applies when compliance with an invalid order would necessarily result in an irrevocable and permanent surrender of a constitutional right. This exception applies when a witness refuses to testify about information implicating the Fifth Amendment privilege against self incrimination. Although legal experts have advocated for the exception to apply when a litigant violates ex parte injunctions restraining First Amendment speech rights, thus far, the exception has not extended beyond the limited confines of self incrimination. And again, cite it. At 1208, the Supreme Court empathetically rejected the suggestion that an individual may disregard a court order simply because it interfered with his exercise of First Amendment rights. To justify her defiance, Robertson may repeat her argument from October 2025 motion to dismiss that the orders to disclose her identity violate the First Amendment protections against unmasking anonymous online critics. Let me reread that. To justify her defiance, Robertson may repeat her argument from her October 2025 motion to dismiss that the orders to disclose her identity violate the First Amendment protection against unmasking anonymous online critics, and that's plural for protections. As recognized in the court's recent report and recommendation, Robertson is correct that an author's decision to remain anonymous is an aspect of the freedom of speech protected by the First Amendment. Signature management and versus Doe. In litigation involving anonymous internet users, courts have weighed the validity of the claims and the plaintiffs need to uncover the user's identities against the First Amendment protection of anonymous speech. Well, we've seen this several times in her writings. Thus, case law supports Robertson's position that the First Amendment may protect against disclosure of her identity. But as stated above, finding a disobedient party in contempt is appropriate even if the order is later found incorrect. And Judge Levy's determination that Robertson must disclose her identity is the law of the case and may not be revisited absent extraordinary circumstances. See Hayden versus Rhode Island. Under the law of the case doctrine, findings made at one point in the litigation become the law of the case for subsequent stages of that same litigation. A prior ruling may only be reconsidered where 1. Substantially different evidence is raised on subsequent trial, 2. Where a subsequent contrary view of the law is decided by the controlling authority, or 3. Where a decision is clearly erroneous and would work a manifest injustice. Even if Robertson argues that the orders were clearly erroneous, she waived her First Amendment argument by failing to assert it in any of her previously filed briefs about the anonymity issue. See Evanston Insurance Company versus Cogswell. Although she made the argument in a motion to dismiss, that motion did not concern the orders to disclose her identity. Okay, it's 1017. Just 4 more pages, maybe 2.5. Neither the court nor Judge Levy was obligated to scour the record on Robertson's behalf to develop her arguments. I've seen that said to me as well, scouring the record to find in the case where there was a pleading for conspiracy, even if it's there. It's not the judge's, she's saying, obligation to look for it, if it's scoured within arguments. That's C. Sutherland versus Warren. That's just my commentary there. Declining to review hundreds of pages of documents that were in the record but were not attached to the relevant motion. As the court has warned the parties, judges are not like pigs hunting for truffles that might be buried in the record. So that's basically, I said that in my own words, but she said it in these words: hunting for truffles that might be buried in the record. Robertson did not raise the First Amendment argument in opposing Evans' motion to strike her filings made under an alias or in seeking a protective order preventing Evans from obtaining discovery about her identity. ECF number 28 and 49. Her sole reference to the First Amendment in those filings was a fictitious quotation misattributed to Doe versus Porter, Sixth Circuit, a case the court considered in its ruling about Robertson's anonymity. ECF 49, page ID 469. See also number 74, page ID 774. Issues not presented to a magistrate judge in the first instance are waived. See Ward versus County of Wayne, and at this number, page 9. Nor did Robertson make the argument in her objections to the court's order to disclose her identity. ECF number 82. Her only reference to the First Amendment in those objections concerned her argument that the court ignored evidence in determining that Evans had made no physical threats against her. ECF number 82. Her only reference to the First Amendment in those objections concerned her argument that the court ignored evidence in determining that Evans had made no physical threats against her. Page ID 1145. I continue. When a defendant does not raise an argument in his objections to the magistrate's report and recommendation, he has forfeited his right to raise that issue on appeal. That's Berkshire versus Dahl and Sixth Circuit. Robertson did raise the First Amendment argument in her motion and reconsideration of Judge Levy's order overruling the objections and directing Robertson to disclose her identity. ECF number 121, page ID 2529 through 33. But Judge Levy struck that motion because Robertson included a fictitious citation in support of her First Amendment argument, despite previous sanctions and many warnings that such citations would not be tolerated. ECF number 124, quoting ECF number 121, page ID 2542. See also ECF number 58, page ID 529, ECF number 74, page ID 783, ECF number 106, ECF number 111. Forfeiting her First Amendment argument was a justified consequence of Robertson's reckless litigation practices. Because Judge Levy ordered Robertson to disclose her identity after the parties had a full and substantial round of briefing, the law of the case doctrine applies. See Evanston Insurance at that number. Actually, that's Westlaw. The court declines to reconsider Robertson's belated First Amendment argument on the anonymity issue. As many times as I've said that. Conclusion. The court thus grants Evans' motion for an order to show cause, ECF number 134. By March 24th, 2026, Robertson must show cause, why she should not be held in contempt and sanctioned for her defiance of Judge Levy's orders to disclose her legal name and postal address. Also, here's other instructions, notice to parties about objections, and this is clear each time. Within 14 days of being served with this order, any party may file objections with the assigned district judge. The district judge may sustain an objection only if the order is clearly erroneous or contrary to the law. Bolded, when an objection is filed to a magistrate judge's ruling on a non-dispositive motion, the ruling remains in full force and effect unless and until it is stayed by the magistrate judge or district judge. Certificate of service. That was her ruling and order today. Thus, the countdown to show cause: 20 days, 17 hours, 3 minutes and 46 seconds. All right. So that is the ruling. That's ECF 144. Let's see. Fair use commentary. Again, in advance, I appreciate that you've been respectful in the chat. I rarely give my opinion openly on these filings, rarely. But an objection to, I'm just thinking of it. No, I'm just not the person, I'm just thinking. An objection to show cause. It's almost like, again, this is procedural. So we haven't gotten to the next point, the discovery yet. But on our way to discovery is this countdown to show cause. Yeah. Yeah. And the clock is ticking. It is. And don't hate on my clock. And, you know, there are filings coming up next week, right? An objection to what I have filed, that's what this next round is supposed to be. Mm-hmm. Objections to my objections to the R&R. I don't know if there had anything to do with clocks. So, but what we have found in the history has shown that somehow, you know, snapshots just get sent. I don't know how that one would be related, but, you know, we'll see. It's what it is. Yeah, fair use commentary. Smash the like. I agree that this judge is no pushover. This is a federal court. And Robertson has said who gon' check me boo. That includes the judge. Who gon' check me boo? That's right. Yes. She still doesn't believe she's checked. She still doesn't believe she is checked. A show cause, that's checked. So now she has to explain why she defied the court's order. Justify it. Why she should not be held in contempt and or sanctioned. So now she's got to formulate. Explain that to the judge. Your rationale. And remember, inside of this, this First Amendment argument, that consideration, I don't know. It's the judge, she'll look at everything. But remember last summer when another content creator was sued, we know who that is or who that was, in California. And when the court ordered a hearing, the date and put the date out, what was it? A couple of months. She decided to ghost another court because she didn't want to turn that camera on. Why? What was the reason for ghosting, not a no-show? She didn't even respond to say, appeal, I'm not even going to show up. No. Ghost. And decided, case closed. I'm going to toss it out. She filed. She filed and then withdrew. Maybe she didn't think that another court was going to be so quick to put it together and, do a conference, to look and find out that a name that was submitted that she knew wasn't a California resident or United States citizen. And by the way, talking about jurisdiction, there is on record that Robertson filed in California claiming, I'll just say something about a jurisdiction. And, this person has lived here and there or claimed this address, domicile, when it suits them. That's the meaning of the sword and the shield. Use the name Danielle Robertson when it suits her, but then comes back as Doe. Uses Jane Doe, uses this Doe, uses this alias, this address, that address, which now I am having to respond to in my current objections. Because she's still saying, you don't know my name. You don't know my address. You don't know my domicile. I haven't been served. I haven't been properly this, properly that. But she wants the same court to protect her rights. And, by law, we are all afforded. We live in a nation, a country of freedom, rights, certain liberties that when we want to be United States citizens and afford the Constitution and have the laws protect us as citizens. That's great. But on the other hand, when this country or someone else doesn't suit us, we say bad things. And you know, the beauty of that is why? Is because we live in America. And she said she lives in America. Oh my goodness. A light bulb moment. No, really. No, really. I have on recording that she says, I'm American, if I'm not mistaken, because we live in America. And that's my right as an American. I got to go back through my files. When she was bragging about SEO and doing something to my business and having her right and freedom of speech in America. But yet she tries to take others' freedom of speech. This anonymous person. Yes, she wants her rights. She wants her right to speak. And people should have their right and they should have their voice. But this same individual strives to take away others' rights. Make that add up. Reconcile it, people. I wouldn't say anything that I don't have a receipt for. Make it make sense, as she likes to say. When it suits her, the sword and the shield. This is my opinion, but I have receipts. As she was going after me and saying she has the right. Well, yeah, with the Constitution, we do have rights. We do have freedom. We do have liberties in this country. We do. As an American, we do. We are a country, a nation of laws. Now that could be argued. I'm sure thoughts are swirling in people's minds right now. If people want the truth, why wouldn't they want people to hear both sides? All sides, right? It's almost 11 o'clock. I'm doing all right, I hope. Her legal credibility is nothing short of, the judge used bad faith. Bad faith. She had a ruling from another court. Bad faith. Let's see. Joanne says she's running out of cards to play. She sees nothing wrong with not complying to the court's order. Okay. Yeah. She's anonymous. However, the judge has made it kind of clear, not kind of, what the possibilities she might be facing. Contempt. Well, you know what? This individual said she's going to get away with it. Yes, you can play that for the judge with the countdown sign to show cause. Play that. She said she is going to remain anonymous. She is not going to be found out. She said if she thought she was going to be found out, she was going to disappear. that she is going to disappear. Who gon' check me, boo? That means the court. She said no one checks her. We will see. If this isn't checked, she doesn't consider this check. No. She said she has layers. She's going to get away with this. That means she's planning. That means she plans. That means she calculates. That means I have the receipt from 2024 when she said she's very calculative, very calculating with the snicker, calculating in advance, plotting and planning. Well, I said it, and I found the receipt that confirmed it. She is very calculating. Her words, not mine. And she's planning and plotting as we speak. 3-4 steps ahead. Let's see if she gets 3-4 steps ahead of the federal court. I don't know. I didn't say she wasn't going to respond. Some people think she won't. So far, she has been non-compliant as far as the court has ordered. She's been defiant. That she just, how did the court put it? She just decides how she's going to do things. Yes, Joanne said, but you can only calculate so much. Thank you. You saw it at the bottom. Because I can see some people are coming in late and maybe, they're going to run with 1 or 2 words and may not know. So the conclusion here in ECF 144 is the court thus grants Evans' motion for an order to show cause. And by March 24th, 2026, Robertson must show cause why she should not be held in contempt and sanctioned for her defiance of Judge Levy's order to disclose her legal name and postal address. Twice she has disobeyed. Twice the federal district Judge Levy has ordered Danielle Robertson to provide the court with her legal name and her postal address. I think I've said quite a bit. Anything else? Yes, check Unwind with Teddy's community wall for any updates or changes. She's playing the Anon card like it's an ace of spades. I wish I could play all of, and give commentary on everything like she does. Plays people's videos. That's basically what she does pretty much in all of her. Yes, play people's videos and give, a reaction. Yeah, I'd love to give my reaction, with the receipt so you could hear it. Okay, that's it. Anything else before I say goodnight? We should end it here. Thank you, everyone, for supporting me. Yeah, but now it's time to say goodnight. Yeah, and please, on your way out, just give me a thumbs up if you don't mind. And if you'd like, you can subscribe. Thanks again to my moderators, and biggest bear hugs go out to each and every one of the Grizzlies and Honey Bears. Thank you for watching. Until next time, I'm Teddy. Good night.